Welcome to the Military Justice Today podcast with your host, Robert Capovilla and Mickey Williams, covering the full range of military law topics from all branches of the armed forces. Today's episode is made possible in part by the law firm of Capovilla and Williams. And now, let's welcome the hosts of the show, Rob and Mickey.
All right, everybody, here we go. Another episode of Military Justice Today. I'm Matt Starosiak, stepping in momentarily for Robert Capovilla. And look what we got here, Rob, in the studio today.
It's Dan the Man Higgins. Dan the Blue Jay.
All he does is win Higgins. Is that what they say?
That's what Rob says, yeah.
Well,
Blue Jay's here.
It's nice to see you, Daniel. It's great to see you. And we got a good episode today, so I'm excited about it. I know Rob is too. How you doing, Robert? Good?
I'm good. It's good to see you.
Yeah, it's good to see you too. I feel like we haven't seen each other in the longest time.
Yeah, I agree. It's our first time in the studio in some time because the last few podcasts were about VA and FTCA work. So that was you, Robbie, and Amanda. So this is the first time that we've sat down a little while.
That's right. That's right. But we are ready to go today. Let's start with a pre-show topic. And this is one that's very near and dear to your heart because I think you told us at one point you were a professional boxer. Is that right?
I've never said that.
What do you mean? Gold gloves, I thought.
No, I never won the gold gloves. I was never a professional boxer. I was never even in the amateur ranks.
He's so humble.
No, I boxed on a club team through high school. And I want to say I boxed on a club team my first year in college.
What about the time in the frat house where the guy challenged you and he said, gloves, gloves, and you knew what that meant?
That's a true story, yeah. Yeah. So our fraternity used to have a policy when some guys disagreed over certain things, how those disagreements would be handled. And there was a group of older guys there that I don't think liked me very much. And yeah, old school.
So he
now
said
it's
gloves,
like
you knew
old
what
school
that meant
mentality.
right away.
Yeah. Mm-hmm.
When somebody says gloves, you know.
Yeah, I mean, it was something like that, right? I mean, it's been 20 years, but yeah, there was a policy in place that I'm not going to talk too much about, that if you had a disagreement over a girl in the fraternity house or whatever, you guys would settle it, and that's the way it was. Now they just file Title IX allegations against everybody. Back then, you just stepped in the ring.
Did they ever have the gloves at Pepperdine? Did they ever have the gloves scenario?
No gloves at Pepperdine.
No.
But I did box for a while as well.
Really?
So, yeah.
Who knew? I didn't know this.
Yep. No, I used it as a way to get in shape when I was going back into the Army as an officer when I was in college. So it was a good way to train up and get in shape.
Well, then you guys are going to love this topic because it was recently announced that Mike Tyson is getting back in the ring against Jake Paul.
I saw that. I think Mike Tyson's going to knock him out.
Yeah.
Okay, so hold on, though. Here's the question of the day, and I'll get your predictions in a second, of course. But the question of the day is, how old is too old? He's going to be 58 in July.
Oh, wow.
Have you seen the videos?
58.
He still looks sharp. He still looks like he packs a powerful punch.
Well, I'm sure he does.
Logan Paul. Logan Paul's a big guy.
Put him in the ground, but
yeah, Logan Paul's a big guy and he's got some reach. Tyson's a little bit smaller, but we've seen what Tyson has done to bigger guys, and I think that Logan Paul's going to have a very difficult time.
Logan Paul's an amateur.
Logan Paul is up and coming.
I mean, he's an
decent.
amateur.
He's decent. He's decent, but this is going to be a big test for him to see if he can handle an experienced boxer, and does he have the stamina to last with somebody like Tyson? That's going to be
Tyson
big.
have the stamina at 58?
First of all, okay, so yes or no, is 58 too old to get in the ring?
Not for Tyson. Not for Tyson.
Okay, Robert?
Yes, I think 58's too old for anybody to get.
Because if you remember, and you guys might not, but George Foreman, came out of retirement, started boxing, and he was 48. And at that time, people were all up in arms about the fact that he was 48 and he was getting in the ring.
Tactically speaking, Foreman is different because George Foreman is a mountain of a man. And Foreman had the most, in my opinion, the most powerful punch probably in the history of boxing. When Foreman hit Joe Frazier in the title fight back before Foreman fought Ali, and he knocked Frazier down 7 times, there's actual video clips that when he hit Foreman and would knock him down, Foreman would lift off the ground. And we're talking about, Frazier. Frazier would literally be lifted off the ground by George Foreman's power. And Joe Frazier is a top 10, top 12 all-time heavyweight fighter in the history of boxing. Foreman is huge. Tyson was always a short guy. Tyson's only 5'8", 5'9", 5'10", or something. And so he's not built the same. And yes, Mike Tyson had a lot of power, but what helped Tyson a lot was he had incredible head movement. He had incredible hand speed, especially with his hooks and uppercuts,
which he does not have now.
Which he may not have now. He's still
certainly
powerful.
Does not have that.
He's
now.
No question. He's still powerful. But I mean, Foreman is what 6'5", 6'6", 6'7".
He's 6'4".
6. Is that all he was?
Yeah.
But even still,
he's a big guy.
250 pounds. It's a different way of fighting. Foreman could sit there and take some punishment and hit you one time and lights out. Tyson at 58, I don't know if that's the case.
You talk about Tyson's height like you could take him. Like I'm hearing it in your voice. You're talking. No. You're like, oh, he's only a 5'8", 5'9".
No,
It sounds like you can take him.
No, absolutely not. Mike Tyson would have hit me one time and blown up my whole face. But I also had there were a lot of conversations in the Capovilla household with my grandfather, Rudy Capovilla, and my father, Craig Capovilla, who were huge boxing fans like I was, about Mike Tyson. And, I'm not as big of a Mike Tyson fan as others are. I don't consider Mike Tyson a top 10 heavyweight of all time. I consider
not
him
even
to be,
in the top 10.
No.
Oh my god! Not even in the top 10.
He's easily in the top 10.
Oh,
Mike Tyson made a career of beating bad fighters.
That's kind of true.
Name one elite fighter that Mike Tyson beat. He couldn't handle Holyfield twice and then bit his ear off. Okay, Lennox Lewis made Mike Tyson look like a chump, a total chump.
There's actually a lot of truth to that.
So, when we're talking
Buster
about
Douglas, he was top shelf.
Well, listen, Buster Douglas was an incredibly talented fighter, okay, who could have been a great fighter.
The
problem with Buster,
the ring stuff.
Yeah, they called him Blubber Douglas for a reason. And that's because after the Mike Tyson fight and before the Mike
500 pounds,
he lived off of McDonald's. But Tyson never beat anybody worthwhile. Ali, Joe Louis, Joe Frazier, those fighters beat Evander Holyfield. Those fighters beat other great fighters.
So let's just tie this up here. So is 58 too old? Dan, you say no. Rob, you say yes. I say yes. I think somebody's going to end up getting hurt or end up getting killed if they keep putting these older guys in the ring. And I think Pacquiao, he just tried to get a license to box somewhere and they wouldn't, whoever sanctioned it wouldn't do so. So
this isn't going to be a real fight, though. It's going to be,
who wins?
A slugfest for the first, half of the round, and then they're going to dance around for another 10 rounds or so. And
well, Tyson, he just fought in 2021. He fought Roy Jones Jr., and I guess everybody said it exceeded expectations as to how good both of them were.
Go
now,
look at the videos of him training. He looks
even
good.
That's
now,
a couple years ago.
Can he last more than a couple rounds? We'll see. But he looks very explosive. We'll see.
So who do you think wins?
Tyson's going to.
You're going to say Tyson.
Him. Yeah.
Robert?
I think Tyson's going to beat the hell out of him.
No, I don't think so. I think those Paul brothers are a lot tougher than a lot of people think. I think they think, because they started as YouTubers, naturally they can't be good. Those guys are good, man. They're both skilled boxers and they're getting better. So I'm going to take Jake. I get him confused. I'm going to take what is it?
It's Logan. I think it's
Paul. Which one?
Paul?
Logan Paul,
yeah.
And then the brother's Jake, right?
Yeah.
Yeah. So I think Jake's the one fighting him, I think. But nonetheless, we'll figure that out.
I know we're only supposed to do one pre-topic, per episode, right? But I do think since we started the podcast off with the Blue Jay, I do think we should probably explain why we call Dan the Blue Jay. I think that's fair. I think the listeners will be confused about why we call Dan Higgins the Blue Jay. So
all right, but don't talk about anybody else specifically because I'm going to have to edit that out.
I'm not going to talk about anybody else specifically. So Dan, when Dan first joined us years ago now, Dan had a separation board or a board of inquiry or something, and the opposing counsel was a Marine and had the code name?
Wait, we're not going to give the code name.
We're going to give the code name is not a real name. We're not giving any real names of anybody.
Okay. Right.
Okay. And her call sign, that's what it was. She had a call sign that now this is a JAG, okay, a judge advocate with a call sign. We were kind of laughing about a judge advocate with a call sign. And then the 06 board president responded to this JAG officer in an email saying, good copy.
Yeah.
And
acknowledge.
And we got a pretty good laugh about that. She actually turned out to be a very pleasant person and had a lot of compliments to say about Dan. And Dan won that board. So there you go.
And then he became
the Blue Jay, which we have a picture of Dan the Blue Jay on our refrigerator in the office. And it's Dan in like this vest that's like grassy. And it's got the Blue Jay stripes on it, and he's got wings.
Somehow his face is put on it,
That's
but
right.
not in a very good photoshopped way.
That's
it's just
right.
kind of stuck on there like
That's
a Mickey
right.
Williams way.
Yes,
That's
exactly.
That's the picture that gets sent out after every win.
That's
We all have
Once
call.
the Blue Jay goes out, then you know.
That's right.
You got an
You don't have
acquittal.
to say you won nothing. You
Yep.
just the Blue Jay picture goes
Yep.
out.
We
That's it.
most of us have call signs, so that when we win, we just send out a picture of the call
That's
sign,
right.
and everybody
Rob's got
knows.
Highlander.
Yeah, mine's
There
Highlander.
can only be
All
one.
right. Well, yeah, let's jump into our topic because otherwise we'll be into this 50 minutes and we will still be talking about boxing and call signs. But let's go ahead and jump into it. So fascinating topic today, one that you guys see in the courtroom a lot. I'm going to take a step back here in a moment because I know very little about this kind of stuff. But what are we talking about today? And let's just kind of do an intro first and then we'll get down into the weeds on it.
Yeah, so today we're talking about a case called United States versus Erickson, and the purpose of this podcast is to educate our listeners and our fellow defense attorneys on how to handle prior false allegations made by an alleged victim of sexual assault in a court-martial. So Dan recently represented an airman in a GCM that was accused of sexual assault, and through our investigation, we had found out that she had made, I believe, 2 prior sexual assault allegations against other individuals. So we had to sit down and kind of strategize as a team with Dan as lead counsel on, how do we handle this? Now, I've litigated this issue probably half a dozen times in military courts across the country. But this one was a little different because we actually had verifiable evidence based upon what we had uncovered that this particular alleged victim had actually retracted a statement of sexual assault. So usually it's, we hear whispers from people, well, she accused this person or this person, and you kind of dive into it and you hope you find some actual substantive evidence. But in this case, we had found out affirmatively that there was a prior allegation that she had rescinded. And so we had to litigate this. And that's why I asked Dan to come on, because not only did Dan win the motion, along with Sean Flood, another attorney from our office, but Dan also got a full acquittal in the court-martial. And I think that was due in large part to their excellent work leading up to the start of that court-martial. So that's kind of the fundamental facts behind today's podcast episode, because I know a lot of folks don't know how to exactly use these prior allegations of sexual assault.
Yeah, so it was a great case. We had, pretty good facts on our side, but, during our pretrial investigation, our client told us, hey, look, I think she's done this before. I think that she has made allegations like this against others, right? So we started reaching out to the government with some very specific discovery requests about expedited transfers and, prior OSI investigations, things that could basically illuminate these prior allegations of sexual assault. We got
So you requested those and you're entitled to them, I'm assuming.
Yes, and we have to get into making our argument regarding relevance and why we need them and why it's necessary. But really what we honed in on is I didn't necessarily need everything from the government because I went straight to the source, right? I found these individuals and who they were. We had a defense investigator track them down. They were both still on active duty. So I call them up and I finally get a hold of them 2 weeks before trial. And I explain to, both of them, hey, look, here's what's going on. I understand you have a busy life and a busy schedule and you have a lot of things going on in your life, but my client has been falsely accused of sexual assault, and I think you know the person that falsely accused him. Do you know this individual? Yes, I do.
Yeah, they knew right away.
And it was right away, this is an evil person. I will do whatever is necessary to help you. So we literally got them on a plane, 2 weeks before trial, scheduled everything, got them out there, and they both came out to testify at a motions hearing.
Okay, so I guess let's back up. So if you want to bring in a prior accusation, right, of sexual assault, that's done outside and prior to the trial, right? You've got
That's
to
right.
go in front of a judge, I'm assuming, and you have an argument, And then what is that like? I mean,
so that falls under
what's the prep work like for it, and then what's the argument like itself?
Yeah, so that falls under a military rule of evidence 412 motion, basically where we want to bring in prior sexual behavior of the alleged victim, right? Now, there's the rape shield law, which we've talked about before, MRE 412, which is designed to keep out the prior sexual behavior of an alleged victim. It's designed to prevent embarrassment, humiliation, where the defense counsel can't come in there and, get into any sexual predisposition to where, you can say, well, hey, she consented to all this sexual behavior in the past. She must have consented now, right? That's prohibited. There are exceptions, right? One of those is a constitutional exception, which we argued that this would violate my client's rights to confront his accuser at trial, right? But to answer your question, when we are bringing in or seeking to bring in a prior allegation of sexual assault, the burden is then on us, the moving party, to demonstrate that that allegation is false, right?
Now, Dan, before you go into all this, I want to make sure we get a few things clear, because we had a lot of discussions behind closed doors about, do we even need to give MRE 412 notice on a prior false allegation of sexual assault? And my understanding of 412, and in fact, I know this because I've litigated this in front of judges, is that the rule itself says prior false allegations of sexual assault are not 412, right?
That's
because
right.
We're actually not talking about sexual activity between two people.
It's a credibility issue.
It's a credibility issue. However, did you decide out of just to be cautious, which is sort of our practice when it comes to 412, right? We want to be conservative in our approach to make sure the military judge has all the facts at their disposal to make a decision either under 412 or another decision to admit the evidence that's not under 412, right? Basic relevancy rules. So did you and Sean end up giving 412 notice? And if you did you make it clear, like, hey, we're only doing this, out of an abundance of caution?
Yeah, and this was such an important issue for the case. We didn't want to do it live, during trial, and then, the judge can say that we didn't lay a proper foundation to demonstrate that the allegation was false, right? We wanted to hash this out pre-trial so that we could get a ruling on it, and then we could strategize, okay, how exactly are we going to use it during trial, right? So we really dug into the case law, and there's other cases out there where judges have ruled that, you did not properly lay a foundation. You cannot just put the former accused up there and ask him, hey, did she falsely accuse you? Yes. Okay, that's not going to be enough, right? So we couldn't do it hastily like that. We had to litigate this in a pretrial motion.
But are you, Rob, is your question to Dan, I think I'm following it, but just to clarify, is your question the strategy behind bringing it up at a pretrial motion versus just bringing it up in the courtroom while the trial's happening? Is that your question? Because you have the choice to do both. You can just keep it to yourself, right? And then bring it up when whoever's on the stand.
And I know we have a lot of members of the defense bar that listen to this podcast, and sometimes listening to us may help them. Sometimes it may not. So here's a word of caution. But
we should probably put our disclaimer out there at some point in this show.
That's right. But here's the deal. So I've successfully litigated one of these in Navy court. Dan just won one in Air Force court. And what we did was we sat down and said, okay, the rule says that prior false allegations of sexual assault don't fall under MRE 412. However, with the way things are in today's kind of political culture within the courtroom, and to keep things as clean as we can, I know Dan made a decision along with Sean to provide 412 notice out of an abundance of caution.
That's right.
So if you're in this position, here's our recommendation. Number one, obviously you find out there may be a false allegation. Number two, make sure you have the facts necessary to request either discovery or production. Okay, you can show it exists. You can show it's necessary and relevant, right? And then number three, conduct your investigation, find out what the facts are, and try to figure out, does it meet the actual standard under Erickson, or is there another rule of evidence that you want to try to admit this evidence under, such as MRE 608 Bravo, which I've done successfully in the past. So in this case, we made the decision to keep it clean, to make sure that we were as forthright with the judge as we could, to make sure we were putting the judge in a position to make a ruling on everything and not be shocked at trial, because if this had come up at trial, and without any
Taking a little
forewarning
bigger risk.
or either
a huge risk.
a motion under 412 or a motion eliminate a pre-admit, this would have been a major problem for the judge. So we gave notice and we let the judge know, hey, we're giving you 412 notice out of an abundance of caution just because we want to be good boys and girls, but it's not really 412. And then Dan argued in the motion, however, we are seeking a ruling from the court to admit this prior to trial. And that led him to the 39 alpha session.
All right, and so we'll get to that motion and the prep work and what happened at it and your advice about it. But what I like about what your team did is two things. One, you had a good investigation, right? You had a good investigator, top investigator, to go out there and actually find this information. And two, you talked about it as a team, which I think is one of the core strengths of Capovilla and Williams. If I could plug the firm, is it's not just one lawyer in an office somewhere outside of base making a big call like this. You're sitting down, you're talking about it with Mickey and Sean and Josh and Brad and whoever else might be involved in the discussion, right?
Exactly. And listen, I'm not shy about what I think about our team at Capovilla Williams. I think we are the greatest military justice team in the country, period. And I don't think it's close. And I think that's in part due to our mission that's very clear at our firm, our passion, our core values. But I think it's also in part because we do have a team. I mean, in our office in Georgia, under that roof, there's 60 years now of military law experience.
Yeah.
And we handle a lot of these issues as a team. But the biggest point you made is investigator. We invest in a very, very good team of investigators, and we have two that we work with pretty consistently. And I can tell you some of the success that you've seen, or now maybe even folks have read about us in the media, doesn't come from us just being passionate lawyers. It comes from us investing the time, energy, resources, and money into having top flight investigators.
Yeah, and you owe it to your client. All right. Well, let's jump back into it. We'll come back to that topic, Rob. We've talked about it in the past, but I think it's worth bringing up in this because here it is in real life. The team concept, the investigator, the importance of the investigator. Dan, let's jump back into the motion, and I guess what I'm interested in is how did you prepare for it, and then a little bit about what happens. And we do have a lot of JAGs and stuff that are going to be familiar with this process for sure. But any unique points that happened worth talking about in your particular case? How did you prepare for it? How do you put the witnesses on, that kind of thing?
Yeah, so I think that something we really had to consider was the case law here, right? Because, organizing witness testimony and everything like that, that's fairly simple. But when you get into the case law, there's an important case Rob mentioned, United States versus Erickson. And this is a case that was in the Army out in 2014. And you had a service member accuse another service member of sexual assault in the barracks. And during the trial, the defense team wanted to bring in a prior allegation of sexual assault, right? And they did not. Basically, what had happened is in that prior allegation of sexual assault, the accused was found not guilty at a summary court-martial, right? And the defense basically tried to rely on that. Well, hey, because there was an acquittal, right, then that should be enough to show that this was a false allegation. And the judge ruled no. Simply an acquittal is not dispositive of falsity, right? That does not mean that it didn't happen. It just means that he was found not guilty, right? So that doesn't mean it was a lie. It was
Seems
false.
Kind of counterintuitive to me, but
yes, it does. And especially, when we get into my case here, you'll see that it did seem very counterintuitive. But in that case, Erickson, it went all the way up to the Court of Appeals for the Armed Forces. They determined that the judge did not err in his decision to keep that prior allegation out, and that the defense had not proven by a preponderance of the evidence that prior allegation was false.
Yeah, and
right?
I think that's an important point worth making, though. It's not enough to know that a prior allegation was made. You actually have to prove that it was false. And
That's
then
right.
what you're talking about now is, well, what's the proof? What's considered proof and what isn't? An acquittal is not, apparently.
No, it's not. And,
that's hard for me to believe. And I realize that not guilty doesn't mean innocent, but still.
Yeah, and when you're getting in there and you're litigating, and your burden of proof is by preponderance of the evidence, which means it's more likely than not, right? It's a 51% standard. It seems like when you have pretty good evidence on your side, getting over that hump shouldn't be that difficult, right? But like Rob said, with the political pressure nowadays, it seems like it's a lot more than by preponderance of the evidence to prove that these are false. It's very, very difficult.
Well, what makes me, I think the word I would use is frustrated sometimes, is in Erickson, the defense counsel has to basically prove by 51%, like we talked about, that it's false. And the case law also kind of suggests there doesn't need to be a recantation, but there kind of does need to be a recantation, right?
Yep.
But if you contrast that with Military Rule of Evidence 413, where Congress back when they passed the Crime Victims Act, I think is what it was called in the early 90s, Congress basically created what is now MRE 413, right? And those are allegations of sexual assault against an accused coming into evidence to show propensity. Well, right now, we've got cases where ex-wives come out 8 years later with no evidence whatsoever and say, you know what, the prosecutor called me 9 times, but on the 10th time I told her I'm now ready for the first time in a decade to say he sexually assaulted me. And the military judges will be like, yes, that's admissible. Yes, yes, the congressional intent here is very clear. But defense, my goodness, if you want to show she made a prior false allegation of sexual assault, you better not only show it's recanted, you better have no less than 36 witnesses to come up here and say she has a character for dishonesty.
Well, that's almost what we had in this case.
Then maybe I'll consider it. Obviously, that's a bit of an exaggeration, but it does go to show you, I think, the contrast between 413 and Erickson.
Well, and I'll tell you about that. So in this case that we just had, General Court Martial, about a month ago, so we uncovered, right, that she had made these 2 prior allegations of sexual assault. We reach out to these folks. We confirm their story. Their narrative is very, very close to hers, right? So the first prior allegation was she was in the Air Force. Her husband was in the Air Force. Her husband was deployed, right? She contacts another member of her unit, a male. They are on Snapchat together. He comes over. They make this plan to hang out. They have a bunch of drinks together. They have pizza together. They watch Netflix. They go in to the bedroom. They hook up. He goes down on her. She goes down on him. She gets on top of him and he finishes, right? By all accounts, a completely consensual sexual interaction. Afterwards, they go out. They have a couple more drinks together. They lay down on the couch. They watch The Office. They fall asleep, right? The AV then goes back to her unit and tells other members of her unit, I slept with this guy. I fucked this guy. We hooked up, right? Basically, again, alluding to it was a completely consensual sexual interaction. None of those witnesses got the vibe at all that something less than consensual had happened. She was basically bragging that she hooked up with this guy. Her husband then comes home from the deployment, finds out about it. They get into, obviously, a big fight about it, and he says, this was rape. You're going to go tell them it was rape. She actually told a member of her unit that her husband told her to go tell them it was rape, and that's what she does. She goes and reports it. So OSI sits down with her, and they go through everything, and she tells, the same way that I just told that story, she tells that story to OSI. And so the OSI agent kind of looks almost perplexed, like, okay, well, help me understand what part of that was not consensual, right? And she says, well, I just felt overpowered. He was so tall and I just felt overpowered and I couldn't say no, right? So what we did with that first allegation is we brought in all of the people that she talked to at the unit afterwards to basically show that this was a completely consensual sexual interaction.
Which was how many, roughly?
We had 4 different witnesses come in, that heard her say that, they hooked up, they had sex, we asked them, did you get the impression, right, that this was less than consensual? Help me understand, the vibes in the room when she came in. And they said, yeah, it seemed like she was bragging about it, right? And then we, had another leader confirm that, yes, she told me that her husband told her to claim that it was rape, right? The judge decided to keep that allegation out and that we didn't prove by a preponderance of the evidence that it was a false allegation.
Wow.
Right?
You surprised, Rob?
No. I think, like I said, under MRE 413, the government's got to climb a molehill to get it admitted. Under Erickson, we have to climb Mount Everest. But Dan is a good lawyer and Sean is a good lawyer, and they're both tough guys, and they stuck to it, and I know they were successful with the second allegation. But the idea that the judge didn't admit that, to me is a miscarriage of justice.
I don't know what else you could need. I guess we're going to find out in a second because you talk about the one that was kept out or that got in. But it's amazing to me that 4 witnesses, all with more or less the same story.
Yeah, they're not lying.
No.
Yeah, they're not coming in there to lie for my guy. They didn't know him, and the one that didn't know him well, right? Yeah. But if you contrast that to, because there's a big difference between arguing this before a military judge and then say that we were going to litigate this at a separation board, right, where it's by a preponderance of the evidence is the standard there, right? I guarantee we would have won at a separation board, right? But because it's before a military judge and this culture and this climate, I think they're very, very careful to bring in these prior allegations of sexual assault.
Yeah.
But the second one, which was an allegation against the AV's husband, right? They basically, she was deployed this time, and she was sleeping around with a bunch of people. She comes home on mid-tour leave, and her husband discovers all of these pictures, videos, text messages, sexual acts, sexual, texts, everything like that. And so he confronts her about it, right? Now she knows she's in some trouble, right? Both in her personal relationship and potentially professionally, right? That she's going on having all of these affairs.
Yeah.
So she goes back on deployment shortly after that, and she makes an allegation of sexual assault, that her husband sexually assaulted her while she was on mid-tour leave, right? So she had a pretty clear motive to fabricate, right? Now, what was interesting about this is that when she made the allegation, she wanted to do it, she wanted to do a restricted report, right? So law enforcement wouldn't know about it, but family advocacy, which is a group that basically handles a lot of the counseling for stuff like this, they're not law enforcement, they screwed it up and they sent it to OSI, so it became unrestricted, basically. And at that point, she then recanted and said that it didn't happen, right? So when it went out for everyone to see and law enforcement to start looking into it and it really to be investigated, she recanted, and the case law says that if there's a recantation, then it is a false allegation of sexual assault.
So by definition, that made
it a very easy determination for the judge. So the judge let that prior allegation of sexual assault in. And so we were able to go in there and argue it, and it was a very important part of our case.
Now, Dan, so you win the motion, at least the second allegation, and you go into opening statements, right? Well, you pick a panel, obviously, you go into opening statements. How did you utilize the false allegation in opening statement? How did you educate the panel members on what they would be hearing at trial about this?
Yeah, so I think what I did is I focused on choices, character, and credibility, I think is what I did. But basically, that's when I touched on it, and I basically say, hey, listen, you're going to learn that she is a dishonest person, and you're going to hear from a lot of people who know her well that she is a dishonest person. And most importantly, you are going to hear that she has made a prior false allegation of sexual assault. She cannot be trusted.
So
right?
at that point, it's coming in. It's all
I know it's coming in,
which I guess is part of the going back to the strategy, Rob. That now it's coming in. You can talk about it in opening because you're going to show that during the trial, right?
Right. And there were a lot of reasons we decided to litigate this prior to trial. I think we sort of had to, given the nature of the evidence and what we wanted to accomplish. But we're big believers at Capovilla Williams that voir dire, opening statement, and cross examination of the accuser are the 3 biggest moments in a sexual assault trial. Closing gets all the fanfare, but studies have shown time and again 70 to 80% of jurors have made their mind up by closing, make their mind up after opening statement who they're going to root for. So having all of this organized and ready to go was the best way to try the case. And Dan, you outline it in opening. You let them know it's coming. Who did you call? Well, let me ask you this. Number one, how did you cross-examine her on these facts? And then number 2, during your case in chief, did you call anybody to essentially kind of get into the nature of the allegation?
Yeah, we nailed it down with our case in chief, and we actually called the guy that she, the former accused, where the judge didn't let that prior allegation of sexual assault in, because we were still able to establish, hey, you knew her from this time to this time. How did you know her? What was the nature of your relationship? in your experience, do you believe that she's an honest person?
Now,
No.
stop right there because, Dan, I love to hear this. All right. And I'll tell the listeners why. Okay. So what Dan did here was very, very savvy and a very, very smart move. Judge comes out and says, in her infinite wisdom, hey, we're not allowing in this first allegation, the one where she bragged all these people about having sex with this guy. So what Dan does is he makes sure that he can establish that this original accused, we'll call him, has the personal knowledge background to provide the court an opinion on the accuser's character, right? And I think that personal knowledge comes in under MRE 601, 602, okay? And essentially what that means is the judge has to make a determination that this person knows the accuser well enough or the reputation well enough to actually put forward an opinion about the accuser's honesty. So what Dan does is, as a form of impeachment under 608 Alpha, he calls the original accused to get up there and say, yes, I know her. Here's how I know her, the sufficient background, okay, to establish that he's got the basis to give an opinion. And then Dan says, in your opinion, was she honest?
So you can get that opinion
Yeah.
without going to the
panel
reasons
knows.
why he believes
The
that.
panel will know.
Yes. Now, the panel will pick up on it likely, like, they're in a romantic relationship, because romantic relationship is not 412.
That's right.
Okay. They were in a romantic relationship, and this guy is up there saying she's not honest. And this isn't even the dude we're going to hear from that's going to say that he was, she falsely accused him. But here's the real.
So he did say they were in a romantic relationship.
Sure.
So he can go
Yep.
up on the stand. He can say I was
Yes.
in a romantic, and I don't believe she's honest. He just can't talk about the.
Correct. However, okay, this is where it gets fun and
Splitting
exciting for
hairs
us
here.
trial lawyers. Now, if the government attacks the foundation of that opinion given by that witness on cross-examination, the rule against introducing specific acts, okay, under 608 Alpha is not applicable, because if they attack the basis of the foundation of the opinion, you then have the ability as the defense counsel to get up there and say, well, Mr. Witness, the government just attacked you about your bias or this or that against this witness. Why would you be willing to say she's not honest?
It's really a chess match.
Because she
Because-
made a prior allegation of
Yeah.
sexual assault
Yes.
against me.
And
So they
this-
were careful not to go there,
Oh,
I'm
yeah.
assuming.
He was experienced enough, yeah.
in
Yeah.
this case, they knew it. I had a Navy case 5 years ago that was a 2-victim alleged sexual assault case where I call this decorated Navy diver who had also been falsely accused by the accuser in that case. And
They tried to attack
this
him.
guy looked like an action hero. I mean, this Navy diving group out of Norfolk was the most fit dudes I've ever been around in my life. And I've represented a lot of Green
The Navy
Berets,
diving community is
Rangers, and all these guys.
impressive. Yeah.
This dude looked like a dude out of a male fitness model. And I get up there and I do the whole, how do you know her? Oh, we were in a romantic relationship for 6 months. We worked together, blah, blah, blah. You know, in your opinion, is she honest? No, in my opinion, she does not have a character. She's not honest, right? Character for untruthfulness, whatever it was. Then the prosecutor gets up and attacks this guy. Well, you don't like her because she lost your admin paper when you were trying to get promoted. And Judge Larson's the judge, who's now a pretty famous judge in military court circles, right? Military justice circles. And I get up there and I say, Mr. So-and-so, why is she not honest? Government objects like it's a horrendous thing. We do a 39A. Judge Larson looks at the government and says, government, I don't know what to tell you. You have opened the door.
Yeah.
You should have looked into this more. Get back on one question. Why do you believe she's not honest? Well, and he looks right at the military panel. He goes, well, gentlemen, she also falsely accused me of sexual assault, and it damn near ruined my entire life. And he's choking up, and his lip is quivering,
Yeah.
and full acquittal, a day later.
But
So-
these things that we're talking about here, they're moving quickly in the courtroom, right? I mean, these things are moving quickly as to
Yeah, it's
who's
very
doing
dynamic.
what and who's saying, right? So
Yeah.
how are you kind of keeping track of it? You've obviously got Sean there. You guys are teaming up on it, but
Yeah, we
how
had
are
a
you
great
kind of
team.
keeping track of what's being said? I mean, it's a lot to digest, I would assume.
Yeah, and that's just comes down to preparation, right? Being very well prepared before we ever step foot in the courtroom, having a plan for each contingency. that if this does come in or it's kept out, how can we kind of still use it in different ways to where we are abiding by the judge's ruling? It's just being prepared.
That's why
and just being able to adapt on the fly.
That's why when Dan's in trial, we don't hear anything from him on the text message thing. It's like, where is he? Where is he?
No, I mean, trial's battle, right? Trial is battle, and trial's the real deal. And that's it's like that for all of us. I mean, when we're in trial, I'm lucky to call my wife one time, once a day, because it's just your sole focus. Everything, all of your energy is going towards one goal. Now, Dan, I know we got to wrap up here soon, but let's talk about
the second allegation.
Who did you call? How did you use it in court?
Yeah, so Sean handled the cross-examination of the AV, and he did a brilliant job. I mean, it was such a comprehensive cross-examination that got into all of it, and he got her to admit on the stand that she did in fact recant this allegation that she made against her husband, right? And at that point, we basically moved on. We knew the case law. We're like, all right, that's all we need, right, to argue this. And
because you had proven at that point that she had given a false statement and recanted it.
Yep.
Where else do you go? Right?
Yeah, exactly. We already know that allegation is, it's coming in. We can use it and everything. So really, just getting her to admit it on the stand, and then we called the husband during our case in chief. And so we had an interesting...
This is the husband who she made the second false allegation against.
And an actual interesting ruling by the judge is that we couldn't get into the content that he discovered on her phone, right? The text messages,
and that's the right ruling.
The sexual video.
That's the right ruling. That would have just...
Right, yeah.
That would have just humiliated her, and you wouldn't have gotten a ton of evidentiary value from that, except to show that maybe she's somebody who gets around a little bit, which 412 is designed to protect and should protect.
Doesn't matter, though, because this is the way that I handled it. I said, when she came home on mid-tour leave, did you go through her phone? Yes, I did. Did you find some things on her phone that were emotionally devastating to you?
Brilliant.
Yes, I did.
Brilliant.
Doesn't need to say anything more, right? The panel already knows.
It's almost better to leave it up to the imagination.
Yep.
Exactly.
That's right.
100%.
That's right. So the panel already knew. And then we got into, the allegation itself, that he was able to say, just very clearly, no, I have never sexually assaulted her. So we kind of, built the context, right, to help them understand, okay, hey, here's where that allegation came from. That was the strife that was going on. He discovered those things on her phone, right? And then it goes into, she makes the allegation directly after. And that goes into our theme, right? That she makes these sorts of allegations when it's advantageous to her.
Yeah, sure. Just out of curiosity, how adverse was he to his ex-wife? I mean, was he all for testifying against her? Was he hesitant? Did he want to do it?
Oh, no, both guys were all in.
Really?
They were all in.
She ruined their lives.
Yep.
She ruined their lives.
And here's the thing. Both of those guys, thankfully, were able to recover somewhat. Their careers were put on hold for probably 8 months to a year, right, because of these allegations of sexual assault. But they were able to recover. They've gone on, and they're doing just fine in the Air Force.
And many don't, right? Many don't.
No, the overwhelming majority, even if they win their case, I mean, whether it's emotionally or professionally, they have scars. And, this particular accuser was one of the more egregious that I had seen. And I don't care what the folks over at CBS, who have quoted me in a number of different articles and things like that recently, I don't care what the folks over at Army Times say. I don't care what military.com says. False allegations happen every single day. They happen. And there are people in the military right now who weaponize sexual assault for their benefit. It is a verifiable fact. We've dealt with it in real life. Sexual assault's a problem wherever it happens, whenever it happens. It should not happen. And it's a very serious crime. But you know what should also not happen and should also be punished? Outright, straight up lies and false allegations. This accuser admitted she lied to take down her husband. That should be punished. That should be punished. Not the accuser who loses at court, because the judge in Erickson is right. A finding of not guilty does not mean any lies were told. The burden of proof is high. But in a case like this, why did she make the allegation to weaponize the divorce proceedings? She made a false official statement. How many clients have we had over the years, Dan, that were prosecuted or separated for making a false official statement and they later recant? I'm sorry, I lied. I didn't really mean it. It was a tough time for me. The Army doesn't care. Air Force doesn't care.
You're getting hammered.
So what you're saying about the media, Rob, to go back to that, is nobody covered this case that Dan just had. There wasn't a big article on the front page of any of the newspapers saying that, hey, not only was this guy acquitted, but there's also these other two. Those were never covered in the media.
No, of course not. I always get a kick out of my quotes in the media because they always cut out the stuff about false allegations. And they put in what they want to put in, but that's okay. They're all good people doing the best they can as well. But no, of course, nobody's ever going to cover this. And I'm pretty certain that alleged victim is still an active duty member of the United States Air Force wearing a uniform that most Americans would be very proud to wear without any repercussions whatsoever. And the next guy that upsets her, you can bet your rear end there's going to be another allegation.
That's unfortunate. Well,
I mean, and that's the thing. Out of all of the AVs that we have, destroyed on cross-examination to illuminate their dishonesty, illuminate their motive to fabricate, and illuminate their lies, I've never seen one get punished, right? I've never seen one. And I mean, when the dishonesty is clear, the false official statements are clear, there's no repercussions for them.
And so there's no deterrent. There's no deterrent either because everybody knows I can make this allegation, and if it works to my benefit, it does. And if it doesn't, then I just continue on with my career.
To that end, not to go too far off the tracks, but to that end, because this isn't the main topic we're talking about, right? But about 4 years ago, I had an Army case, a general court-martial, and we had a motions hearing, and I filed a 412 motion to say that the accuser was in a romantic relationship with another NCO, and then that she had a motive to fabricate because that NCO was really good friends with my client. So when she got caught hooking up with my client, she made the allegation of sexual assault. Well, what she didn't know was we had an investigator that was conducting a full-scale investigation and had uncovered definitive evidence to show that she was living with this NCO, living with him on a daily basis. We had photographs. We delivered fake flowers to this guy's house. She was the one that answered the door at 6 o'clock in the morning in her pajamas. She gets on the stand. She doesn't know we have this. She gets on the stand. She answers definitively that not only is she not in a romantic relationship with this man, she barely knows him. They've only crossed paths in the unit.
Never been to the house.
Never been to the house. So I then bring on my investigator. He testifies. We admit all the evidence to clearly show that she just committed perjury in the courtroom. She just committed perjury in the courtroom. The military judge asks to call her back as a witness to read her rights. Okay? Fact. Nothing happened to her.
Yeah.
Nothing. She lied to crush another man's life, and nothing happened to her.
That's just counterintuitive victim behavior, Rob.
Well, that's a podcast for another day.
Well, and I think we could go, I mean, I just feel like we've just scratched the surface on this topic in this podcast, and we've gone a good long time. Maybe we do another one, because I'd love to hear some more about like your reaction when the judge gave the ruling on the two, whether they were coming in or not. I'd love to hear what your reaction was. But I don't know that we have time for that today.
No, but
it's been a great episode, though.
Yeah, and for 2024, we're going to do kind of more narratives of some of our cases in the courtroom, because I think our readers really enjoy listening to that. And I also think it's important to do what little bit we can as a firm to try to combat this idea, this overblown notion that the Army, that our military service members have are more likely to commit sexual assault than other members of society. And I think that the veil over the court-martial process, in part, is to blame for that. So one of our goals this year with the podcast is to kind of illuminate what really goes on in these cases. What are the real facts? To do what we can to, get our message out there a little bit, because if we don't do it this podcast, nobody else is going to publish it. I can tell you that much.
No, and I think these topics are great, and we know our listenership pretty well, and they're going to love this episode along with others, and we'll do a follow-up as well. But let me put the disclaimer out there. We probably should have put that out first, but nothing in this podcast is designed to be legal advice, certainly doesn't establish a lawyer-client relationship with anybody. If you need a lawyer, get the best lawyer that you possibly can. But this show is about opinions, and while the opinions are accurate, they're just opinions. All right, guys. Well, great episode. Anything else that we need to follow up on, or we're good to go?
Nope. Congratulations, Dan. I was on the treadmill. I'm trying to get my butt back in shape when I heard the good news and about the acquittal in this case, and you did a very, very good job, and you made us all very, very proud. And I have no doubt that There are going to be a lot of service members saved by your skills in the future. So well done.
Thank you.
Yeah,
Rob.
and Sean too, because I think you guys really teamed up on it, which is great to see. So
We had a great team.
Yeah, so great job. And you've won other ones here recently too, so we're going to have you back to talk a little bit about those. All right, guys, well, great episode. Another one of Military Justice Today in the books. Take care, everybody. Stay safe.
Thanks for listening to the Military Justice Today podcast with your hosts, Robert Capovilla and Mickey Williams. This show was made possible in part by the law firm of Capovilla and Williams. For more information or to listen to more episodes, visit militaryjusticetoday.com.